are mediation, arbitration, and litigation. Mediation is somebody who's going to bring two parties together, allow them to shake hands, and get on with life. But whatever the mediator allows the parties to agree is not binding on those parties. It is not law, it is not, he or she is not a judge. Arbitration, on the other hand, is judgment, which is called an award, by an arbitrator or a tribunal, a panel of arbitrators, either 1, 2, or 3, who are all experts in the particular area. So if you have a maritime dispute which is to do with engines and technological stuff, don't ask me, because I'm not an engineer. If you have a problem with commerce, and charter party contracts, and bills of lading, and lay time and demurrage, and so forth, then I may be able to assist. Because as arbitrators, similar to, but not always the same as judges, our word is binding on the parties, but we are in our second, or sometimes even third career. So my first career has been freight forwarding, shipbroking, chartering, ship owning, ship operating, insurance, marine insurance, and futures broking in gas oil. That was my first main career. My second career is as an arbitrator, and I suppose linked with all of those is as an educator. I've been teaching since 1984. I'm still learning, and I like to think I will continue to learn. Judges, however, are frequently asked to look at cases, and they will be appointed just because they happen to be on the podium or on the bench or in court on a particular day, not necessarily because they happen to be experts in that particular arena of law. And we have had quite a few fairly recent judgments given by very eminent judges who don't have a clue about shipping. And therefore the results, the judgments, have been very awkward, not to say embarrassing, and plain wrong. There's one extremely clever, well-respected, highly regarded judge who until recently was a judge of the High Court in England, who's now become a Court of Appeal judge, so she's risen very quickly. She's very intelligent, very charming, I've met her. And she's an extremely good family law judge. She understands families and family law very well. She does not have any idea at all about our world of shipping and trade and commerce. And yet she gave judgment which is binding on a number of parties just because she happened to be the judge on duty that day. Fortunately, a very well-known judge, also on the English High Court circuit, followed with a very similar case about 6 months later, and fortunately for most of us, he reversed her decision and simply switched everything around 180 degrees. But there's a danger in that, because then which judgment binds us? Whereas arbitrators, you will choose an arbitrator because of his or her experience in that particular field. And there lies a very big difference. You may have a complaint. You may find a search engine like this, and this is where modern technology may well assist you, as opposed to simply having a dispute with another party and going to an arbitrator and asking for an opinion. This is how it started with the London Maritime Arbitration Association, which was before the SMA, the Society of Maritime Arbitrators in New York, quite a few years beforehand, and the LMAA, the London Maritime Arbitrators Association, is by far, without question, the biggest, handling some 2,500 cases a year, whereas the SMA in New York is handling roughly a quarter of that per year. And there are other differences which I will cover with you in a moment. The process of reaching an agreement is, first of all, know what it is that you want. And secondly, try to find out and then know what the other party wants. Try to avoid conflict when you are trying to come to a decision and an agreement, and find some common ground, something on which you can all agree. Test the acceptance of your ideas, be creative, be imaginative, and then when you do finally have an agreement, for goodness sakes, confirm it. Otherwise you may have a disagreement about what you think you may or may not have agreed, which would be silly. We need to think very much about the letter of the law. We're all dealing with contracts, whether in our personal lives or in commerce, and we need to look at the precise letter of the law, exactly what it says. So what precise words were used in a contract. But we also have to think about what was the intention of the parties when they provided those laws, or rather those letters in the contract. What did they mean by such and such a word? So we must also think quite often about the spirit of the law, the intention of the parties. My next little illustration shows you that the letter of the law is not always the same as the spirit of the law, and this may not translate very easily, but we have here the letter of the law and of course the spirit of the law, which of course has a double meaning. I was giving some serious thought to this particular subject that was given to me in July, and I spoke to a few of my friends and colleagues in London, one of whom has been very involved the last 2 years in what she calls top secret idea with very senior judges that information technology, AI, artificial intelligence, she says, it's not a question of when, but if. So the notes that I wrote when I was talking to her just a few days ago about this read as follows. Some practitioners are working towards one and only one international platform for all kinds of arbitration, using one or possibly two software creators and vendors, and not that this would be a platform per topic of arbitration, but one for all industries, for example, shipping, construction, family matters. It is inevitable, she said, that this will happen without conflict of laws, whichever law applies. And it will be used for giving notice of arbitration, diary notices, and then the whole process of the arbitration process will be continued as an automated process. There are some discussions at some top legal levels, including very senior judges in the UK, with whom she is talking, of when, not if, the New York Convention 1958 states or countries who have subscribed to that and not only signed but ratified that convention accept such electronic awards made effectively by computers. Artificial intelligence programs have been tested for the past few years, apparently proving that 4 out of 5 artificial intelligence tests reached the same judgments as court judges. So of course, being an inquisitive person and a shipbroker, I immediately said, well, what about the 5th element? And she said that the 5th element is human input and the interpretation and the feel for a case based on experience, which computers and AI cannot possibly have. This will present a problem if trying to test arbitral awards, and this is, I think, where we are going to come unstuck if we wanted to use artificial intelligence for arbitration. Because, as you will see shortly, the majority of arbitration awards are never publicized. Therefore, how do you know what was decided, and therefore how can you test whether an artificial intelligence robot would have come up with the same decision? I spoke to a very experienced maritime arbitrator, friend of mine with whom I've been working for many years, and he also had some comments. He said that using artificial intelligence may lead to the possibility of hacking into people's computers and looking at sensitive documentation which might have been the key for a witness, and suddenly everybody else is going to know about what that witness may have presented. And that, he thought, and I have to say I agree with him, may present a problem. Secondly, as I mentioned just now, arbitration awards, arbitral awards, are not publicized, except mostly in New York, but elsewhere in the world they are not. Therefore, confidentiality is a huge issue for arbitration, because if you go to court, everything that is said is in the public domain. And therefore, not only the judgment, but who was involved, where, what, name of the ship, names of the ports, everything and everybody involved will become public knowledge. That is the very reason why many players, including charterers who are traders, commodity traders, prefer to keep their secrecy by going to arbitration, because we keep our mouths shut. We do not reveal any details. My friend and colleague Patrick also suggested that using artificial intelligence may perhaps lead to manipulation of shipping, for example, shipping markets or other markets. And I fear that he may be right there too. My own view, JDB being my initials, is that such tools can certainly help, but will not and must not be allowed to replace human beings. Inexperienced practitioners in any industry, including shipping and arbitration, should not be able to search for judgments or matchmake like electronic dating sites and then believe that they fixed a ship and a cargo without any problems. Furthermore, such algorithms are surely only as good as the people who programmed them, who created them. And if those people are wonderfully expert at creating algorithms but may not understand or have the experience of shipping or trading or the law, then I fear for the future in that regard. There is, nevertheless, a very serious conversation that's been happening for a while regarding electronic arbitration or e-arbitration. And there is a most interesting Glaswegian, Scottish professor, lawyer, who's called Richard Susskind. And there are a couple of YouTube interviews which are certainly worth seeing, and I will share all these slides with you later, of course. And the first lasts for about half an hour, and the second is about an hour. And it is certainly worthwhile listening to what he has to say. He advocates, and he's been out in the wilderness for about 15 years, he advocates greater use of artificial intelligence in the law, right across the board, not just in shipping. What he says is fascinating. I'm not sure I buy into all of it, however. What he has proposed, and he's now come out of the wilderness, some people are beginning to listen to him quite carefully, is to break down legal work, the work of lawyers, by the use of artificial intelligence, deconstruction of traditional practices of lawyers. So are lawyers becoming project managers rather than acting as lawyers? Especially, this will apply to in-house lawyers. And is this only threatening, or is it perhaps so-called lawyer bashing, if lawyers do not want to move onwards into the digital age? Should lawyers become risk managers in order to prevent a client's crisis? We should have dispute avoidance, he says, rather than dispute resolution, and there I completely agree with him. This can reduce costs of legal services, which are usually charged at so much rate per hour. The obvious temptation is therefore to spend more time on a case, and it won't surprise those of you amongst us who are lawyers that a criticism of lawyers is often they're spinning out the case for as long as they possibly can in order to earn more and more money. This is a very old accusation, it's not new. It may be better therefore for the client if lawyers were to offer a fixed cost to the client, but not at a loss to the lawyers. Therefore, how do you know how much time you are going to spend on a case in order to give a fixed cost? Therein is the problem. Modern tools can be useful, such as Facebook or LinkedIn or Twitter or other similar, but they will not, and again, my opinion, replace human beings and experience. When we come to maritime dispute resolution, in my world, we start with the shipbrokers, because we are the ones, as brokers, who've put the two parties together in the first place. We helped to create that charter party. We know exactly what the owners and the charterers wanted. If that doesn't work, and usually about 80% of disputes are resolved by the shipbrokers involved with the owners and the charterers. But if that doesn't work, then the next stage would be mediation. which is not binding on the parties. The mediator does not keep any records. The whole thing lasts for one day and costs about $3,000 US, which is exceptionally cheap. If you consider that at least 20 or 30 times that will be spent just preparing a case to go to arbitration or to court, let alone actually having an arbitral tribunal hearing or a court sitting. If mediation doesn't work, then you would go to court. Or, and shipbrokers are very often persuaded to use this route by their clients, especially if they are charterers, traders, they will go to arbitration instead because of the secrecy that arbitrators need to respect. So the people involved in arbitration are the arbitrators themselves, of course. Often, solicitors and barristers, under English law, we have a dual system of law. We have two personalities, solicitors who deal with the client and the barristers who address the court, as we say, or speak directly to the judge or to the arbitrators on behalf of the client through the solicitor. Or you may have an advocate or an abogado who is one lawyer talking to both the client and the court or the arbitrator, depending on which system of law you are using. You may well also have the use of expert witnesses who are, and the emphasis is here on expert rather than witness. They are not people who may have witnessed something, but they are experts in a particular field. So right now, for example, you were talking, sir, about the Gulf of Aden and that part of Somalia, and I am fairly familiar with quite a lot of the work that's been happening there through the UN, and I was involved with peacekeeping forces and so on. And I am an expert. I've been called as an expert witness to a court case that's been running for at least 4 years already, and I'm due to appear sometime next year. This is how long the case is going. As to the meaning of OPL, outside port limits, as opposed to outer port limits in Aden, in the port of Aden, as you know, right next to Yemen with all those problems. Was a ship actually outside the port when she was attacked, or was she in the outer port limits when she was attacked? So I don't think an artificial intelligence programmed computer could give you the right answer to that, for example. Claims consultants, such as I have been for quite a number of years, obviously not in the same case where I'm appointed as an arbitrator, are very useful to work from within the industry rather than lawyers from without the industry. So why choose arbitration instead of the court system? There are various advantages. Most especially, and I'm talking here under English law with the English Arbitration Act of 1996, most especially the key advantage is privacy, confidentiality. We do not talk about the parties or the case to anybody, not even to other arbitrators. Obviously, if I'm on a case with two other arbitrators, we will know who the parties are, obviously. But we don't discuss with anybody else. So I'm frequently called by fellow arbitrators, "Hi Jeffrey, there's an owner who says this, a charterer who thinks that, what's your opinion?" No names. And I don't expect to ask for any names either. It's irrelevant. Likewise, I will speak to colleagues and say, "I've just been appointed in this case, my view is such and such. An owner says so and so, a charterer, no names. What do you think?" And we will discuss. Perfectly reasonable to do that, but no names. Whereas other regimes do spill all the beans and do give out names, and in our opinion, at least in England, that is wrong. You'll notice perhaps that I've created this series of advantages in the shape of an hourglass. So privacy and confidentiality is key. English law, by the way, governs some 90% of charter parties. Informality. We do not wear wigs and gowns as you would find in court. We would wear a suit and be fairly regular human beings, whatever that means. Speed. Arbitration is almost always far quicker than going to court. There are a few exceptions, but generally going to arbitration is quicker than going to court. You do not need to have lawyers if you want to go to arbitration. You can have them, and they're often very expensive, but you don't need them. You can represent yourself. If you go to court, you have to have lawyers, and usually very expensive ones. The seat, and I'll come back to that in a moment. The seat does not mean that upon which I sit. It means the place of arbitration and its legal regime, and which law will apply to a case. the finality. An arbitral award is final and binding on both parties. It is just as final as a judgment from a judge in court. There's a great deal of control and what we call party autonomy nowadays in arbitration, in that the parties can choose many more things than they could if they went to court. They can choose, for example, whether to have 1, 2 or 3 arbitrators. They can choose whether to have arbitration on documents only or at a hearing, which becomes expensive and time-consuming. They can choose whether or not to call expert witnesses. They can choose which law to apply. They can choose lots of things. That is not open to them if they go to court. The cost is usually far less than going to court, and interest, as and when it is awarded or given to a winning party, will include compound interest as opposed to interest from court, which is simple interest. So simple interest simply means, let's say, 5% of a figure for the previous 4 years. That's 5% for year 1, 5% of the same original figure for year 2. Whereas compound interest, the interest builds on itself year by year, which effectively means you replace the interest that you would have lost that you would have gained had your money been in the bank and not in somebody else's bank. And above all, probably the most important after confidentiality as an advantage is the expertise of the tribunal, of the people whom you appoint as an arbitrator. We are not computers, and computers cannot have the experience that we have. I don't have experience in engineering. My engineering friends don't have experience in charter parties' bills of lading and laytying. There are some disadvantages, but not many. Some people say the cost of the arbitration can be high. Generally, that is not true. It is not higher than going to court, usually. But if you decide to have a hearing, that is to say, sit before 3 arbitrators in a room with lawyers either side, and witnesses and expert witnesses, that can become fairly expensive because you need to pay for the arbitrators at £1,000 per day, plus the rent of the room, plus meals for 25 people, and so on. That can become quite pricey. But the majority, by far the majority, of arbitrations are not at hearings, they are on documents only. So the documents are sent to one arbitrator and to the other, and the arbitrators simply look at the documents, discuss amongst themselves, and get on with life. There is no legal aid involved with arbitration that is not available. That is irrelevant to us in shipping and commerce because legal aid is only for those individuals who can't afford a lawyer by themselves because they don't have enough money. That is for individuals, and very often in criminal cases, irrelevant to us. Sometimes arbitrators may give the wrong award, in which case the losing party will think that they are incompetent. Rubbish. They may have given the wrong award in the opinion of the losing party, of course, because they lost, not because the arbitrator was incompetent. You may want to vote with your feet by never appointing that arbitrator again. That's your choice, that's your right. It doesn't mean the arbitrator was incompetent or unable to do his or her job. There is a very, very small percentage, really tiny, of some arbitrators in certain regimes who tend to find in favour of the parties who appoint them. To me, this is horrendous and not at all justice and certainly very wrong. If I'm appointed by an owner, I may find in favour of the owner or not, depending on the presentation of that owner's case. Just because I was appointed by the owner does not mean that I will find in favour of that owner. In fact, very often the contrary. There is no appeal against an arbitral award unless it's on a point of law. So if you believe that there's a question of fact involved, tough. You should have presented your facts better. But if there's a question of law, whereby you believe that the arbitrator may have made a mistake in interpreting the law, that you may appeal. But, and it's a big but, if you appeal, you go to court, which means you're in the public domain, which is the very place you didn't want to be. There are some changes from the English Arbitration Act of 1996, in the 1996 Act, which replaced the previous so-called trio of acts from 1950, 75 and 79, most especially party autonomy, that is to say the parties can have much more control about what they do in a case. Compound interest I've already told you, whereas courts can only grant simple interest. A reasoned award, just like a judgment from court, we as arbitrators are required to give the reasons for our award in detail, pages and pages of it, rather than just saying, you're right, you're wrong. That obviously is not correct and not sufficient. There is a right of appeal, as I said, but only on a question of law, and arbitrators are immune. You cannot sue us. If we look briefly at the London Maritime Arbitrators Association, with which I've been involved now since 1994 as an arbitrator, there are particular types of case which are mostly commercial: bills of lading cases, connoissement if you prefer, charter party cases, contracts, ship arrest, for which Panama is of course very famous and rightly so, and other trade contracts. It is a self-regulating organization. We're a very small group of people with a lot of experience who regulate ourselves. We are not the same as the much bigger and frankly behemoth giant called the ICC, with the International Chamber of Commerce, who are, well, to be polite, are different. I have heard of cases which I found abhorrent and really, really worrying, that the ICC Secretariat in Paris has not only published an award by an arbitrator, but edited it and changed it. And I find that very worrying. The latest rules you can look at on the LMAA website are from 2017. This is the point of the main thrust of this talk. This here. If you go to the LMAA website, as you can see I did on Friday, and I do very often, there's a search engine. That is where artificial intelligence may perhaps come into play and be very helpful as a tool. You can look up cases, you can look up people, you can look up particular clauses. You can do this with very many search engines and very many websites worldwide. You know that already. That is the tool that can be used, but it's not to be used to replace human beings. There are 4 levels of case under the LMAA terms: small claims procedure, fast and low cost arbitration, intermediate claims procedure, and full arbitration, which is up to any amount. The only one that you need to think about is if you're going to go for small claims procedure for any claim up to $100,000 US dollars, which is a total of £3,000 for the entire case to be handled within maximum 2 months. The only difficulty is there's no appeal from a small claims procedure, so you take your choice. But from FALCA, intermediate and full, you have an appeal in the way that I've just described, on a question of law. We are a very small but influential number of arbitrators. There are 30 full members who do nothing but arbitrate. There are 27 aspiring full members, those who wish to become, and they're the young who are coming through, and some of those 30 are dying off or will retire. And many of them are former judges, barristers, solicitors, lawyers, P&I club lawyers, engineers and shipbrokers. And there are approximately 60, or 59 plus me, part-time supporting members very active as arbitrators. I have some 15 or so cases per year. I don't do it full-time because I'm busy lecturing and doing other claims work, but I'm still active as an arbitrator. There are in London, I don't know whether you can see these figures behind me or see through me. I'm a transparent camera, so maybe you can see through me. In London we have, the latest figure was last year, 2,533, so over 2,500 appointments, which led to 480 awards. In other words, 480 cases went all the way through to an award. Quite a lot of appointments are simply made to frighten the other side, and then everybody capitulates. Whereas a similar figure from the SMA, the Society of Maritime Arbitrators in New York, is usually about 750 per year. So we're talking of quite a lot less. London is without question the big one, and mostly because, not only, but mostly because English law has been chosen by the community of shipping and trading to be the law that governs the majority of contracts. In New York we have, as I said, the SMA. We also have Singapore Maritime Arbitration, which is coming on quite well. They have 120 cases a year now. Hong Kong, Shanghai, Seoul and Dubai are the fairly new children in this particular family, and Hong Kong and Shanghai are having roughly between 80 and 100 cases a year. Seoul and Dubai less. Building up slowly, but nowhere near the might of SMA in New York, and certainly nowhere near the powerhouse which is the LMAA in London. The SMA, as you can see here, Society of Maritime Arbitrators, is the equivalent of the LMAA based in New York. And US law, or most especially New York State law, is different from English law in one main regard, and I will come up to that fairly shortly. I'm aware of the time. You may be able to enforce a foreign arbitral award, foreign meaning made in any other country, in accordance with the New York Convention. And those of you who are lawyers will be familiar perhaps with this New York Convention of 1958, and if you want to look more at it, you can, if you can't sleep one night, you will be able to go on here, and within about 45 seconds you'll be... In other words, you can enforce an award made in one country in the courts of another country, under that other country's law, in that other country's regime, as long as both countries are subscribing members of and ratifying states of the New York Convention of 1958. This governs by far the majority of countries, shall I say, sensible countries in the world. An iceberg. I use this only because roughly 1/9 of an iceberg is above the orange juice line or the water line, and quite a lot of it is hidden below, including some dangerous areas which Captain Smith discovered when he was in charge of the Titanic in 1912. Yeah, I'm sure you will see the film with Kate Winslet and Leonardo DiCaprio. This iceberg is, of course, obviously not real, but it's quite an interesting take on the kind of ice that you will never see in the shape of Africa. But more importantly, why am I talking about ice? And this obviously is not real. But I am talking about shipbrokers now, very briefly. Many shipbrokers nowadays use artificial intelligence and tools, electronic tools, in order to help themselves with communication. Often they will use something called Yahoo Messenger. Or they use something fairly new, which is called ICE, which is Intercontinental Exchange. And I have an example here of, whoa, where did that happen? So here you can see not only the hour and the minute, but even by second, and you can count second by second of the conversation. So that if you have an offer that's made, which is valid until, in this example, 4:18, you can count down until you're at 4:17 and 59 seconds, and then you can still say fixed and you're within time. That's a very powerful tool. It's a tool. Another example is this. It's not very clear to read it. But both of these are taken directly from a laptop computer, but not mine, from a colleague of mine who uses this regularly. And again, it's showing the date, the hour, the minute, and counting down second by second. Very useful tool. There are 3 types of shipbroking activity, to be brief: dry cargo chartering, tanker chartering, and sale and purchase. When it comes to sale and purchase, we talk about new builds, second-hand market, and scrapping or demolishing vessels, demolition. The second-hand market is by far the biggest. There is other activity for sale and purchase brokers, which is where artificial intelligence can come into play. They provide valuations for owners and financiers. They won't have all those facts in their head. Of course, they will need to rely on search engines and their own records for that. They will provide guidance from the current market and also from recent sales, and thorough research of historical valuations using sales records or depreciation records, and of course also records from those banks or bankers who have lent money for those previous purchases. There are 3 types of chartering shipbroker who are not involved in sale and purchase. I could say they are the good, the bad, and the lazy, but in fact they are those involved as owner's broker, or as charter's broker, or as competitive broker. An owner's broker is either exclusive, the only broker involved with that particular ship owner, or direct, speaking directly to the owner, but not necessarily the only one. So that owner may have a shipbroker in New York, one in London, one in Piraeus, one in Singapore, one in Sydney. They're all dealing with different time zones or different geographic areas or different markets. They're all talking directly to the owner. Likewise, charterers brokers will similarly be either exclusive or direct, whereas competitive brokers have no particular loyalty or allegiance either way. So if you are an owner's broker, you'll be promoting your owner's vessels in the marketplace, and you're looking for the competition, that is the other vessels. And if you're a charterer's broker, you're promoting your charterer's cargoes in the marketplace and looking for the competition, in other words, other cargoes. And if you're a competitive broker, there's no particular loyalty or allegiance one way or the other, and therefore you are very useful as an independent analyst of the market. And you tend to specialize in particular types of trade. Individuals and small niche or specialist firms are unable to cover the entire market, and therefore they tend to specialize in one of three main activities. Either types of ship, or possibly types of cargo, or possibly areas of the world. So you may be sitting in London dealing with the Brazil desk, or you may be sitting in Sydney dealing with the US market, for example. We have a very strong code of conduct in shipbroking, and our word, our bond, is the motto of the Global Institute of Chartered Shipbrokers, of which I have been a member since 1976 and a fellow since 1979, and is also the motto of the Baltic Exchange, the shipping exchange, which is in London. There's no mystery about that. There is a very real reason why both of these institutions share the same motto, because for many, many years, until 1992, the Institute of Chartered Shipbrokers had its head office in the Baltic Exchange, and there's a hugely strong connection between the two. The Baltic Exchange was then blown up by the IRA, the Irish Republican Army, the terrorist group, along with me, and I'm very lucky to have survived. And the Baltic then moved to another building nearby, and the Institute found another head office building for itself. The Baltic Code is very much a gentleman's agreement. Of course, ladies are involved now as well. It's the gentleman's idea of what is right, what is morally correct. And that you cannot replace with computers. BalticExchange.com, you can look at that if you wish. It's used to search and advertise ships and cargoes, and it gives weekly reports of fixtures. You can use it in the telecommunication system as well. There are brokers who have duties towards their principals, their owners or their charterers. The application of basic agency law, I don't have time now to go through everything to do with agency law, it's quite a big subject in itself, but we as shipbrokers are agents. We are bound by the authority or permission given to us by our principal, either that as an owner or as a charterer. We may have to act as an agent of necessity. Sometimes it is necessary to breach that authority and to do something which is in our principal's best interest, even though it is not necessarily what he or she said we may do. And that depends very much on trust. Again, that's a human relationship based on experience, cannot be